All right, we're going to go ahead and get started. So on behalf of the Immigration and Nationality Law Review, I'd like to thank all of you for coming here for our final speaker event of the year. Today we are pleased to welcome Professor Phillip Torrey as our speaker. Professor Torrey is a lecturer at Harvard Law. There he teaches a class regarding crimmigration, which is the nexus between immigration law and criminal law. He also supervises several clinics there. He is the supervisor for the Harvard Immigration and Refugee Clinic, which handles asylum applications, VAWA petitioners, and other forms of relief. He is also the supervising attorney for the Harvard Immigration Project, which represents people seeking lawful permanent resident status and people seeking bonds for immigration custody. So today he will be our speaker. We're going to hold questions until the end, so we will reserve time after he speaks for any questions. So please welcome Professor Torrey to the stand, and he'll give his speech.
Thank you, Ryan, for that introduction. Thank you for having me here today. This is my first time in Cincinnati, and I have to say it's been an incredibly welcoming experience. Everyone on the Journal has been very, very hospitable. I have to tell you a story. This morning, after I left my hotel room, I went for a short walk to try to find some coffee, and I walked down the street to a Starbucks that I had hoped would be open, but unfortunately it wasn't. And so I continued to sort of wander around the streets in downtown Cincinnati, and a doorman stopped and asked me if he could help me if I was looking for something, and I told him I was looking for some coffee. And he went out of his way to walk me about 3 or 4 blocks down the road to a place in order to get coffee. I just thought that was amazing and something that unfortunately you don't see in Boston. I don't know if anybody else here is from Boston. Anybody from Boston? Okay, so I can rip on Boston all I want. Anyway, thank you, Ryan. Thank you, Josh. Thank you to the editorial board of the Immigration and Nationality Law Review for having me here today and for publishing my paper, Principles of Federalism and Convictions for Immigration Purposes. I also want to thank Professors Vasquez and Professor Menk as well. I understand that I am the caboose on a four-part speaker series. You've had some incredible professors here to speak to you already. I hope that I can continue to do that series justice today in my talk about my paper, Principles of Federalism and Convictions for Immigration Purposes. So I don't have a PowerPoint presentation today, and instead what I'd like to do is give you a little bit of a roadmap for the talk that I'm about to give. I'm going to give you a little bit of a background on how convictions, criminal convictions, state criminal convictions work in the immigration, federal civil immigration field. I'm going to talk to you a bit about the definition of conviction for immigration purposes, which, as you'll soon see, is very different from definitions that states have for their own criminal dispositions. I'm going to talk to you about something I call deferral programs. And so deferral programs are certain kinds of state criminal dispositions, or really result in state criminal dispositions. And many of these deferral programs will also satisfy the immigration definition for conviction. And deferral programs, in large part, are not considered convictions for state law purposes. And when they do qualify as a conviction for immigration purposes, I argue that they frustrate the real purpose of a deferral program, which is to allow a person to not have the negative stigma, the consequences, the collateral consequences that attach to a normal criminal conviction. Then I'm going to move to talk about a couple of recent U.S. Supreme Court cases that talk about issues of federalism and equal protection, but mostly federalism. And I want to use those cases to present an argument to you that there may be a way to meaningfully challenge the Immigration and Nationality Act's current definition of conviction. So I think I have to pause. I think that immigration scholars are gluttons for punishment in that we're constantly looking for ways to challenge this notion of the plenary power doctrine that Congress has. Usually it's futile, but what I argue here today is that there is a way to challenge the immigration definition of conviction, have a meaningful review by a court, which may not be successful in terms of actually having a court find the immigration definition to be unconstitutional. But I do think that a meaningful review will have some purpose in and of itself. And I'll explain what I mean by that in the end. Okay, so as a way of background, so criminal convictions. Criminal convictions in the immigration context can result in some of the most severe immigration consequences. I'm sure many of you are familiar with immigration law, but an individual who's a non-citizen with a criminal conviction can be deported. They can be barred from being allowed to lawfully enter the country. There are many bars to different forms of immigration relief if you have a criminal conviction, for example, asylum, withholding of removal, all sorts of discretionary forms of relief a person's ineligible if they have a certain kind of criminal conviction. The mandatory detention, that's a big one. I know that that's something that Professor Garcia-Hernandez talks about a lot. Certain kinds of criminal convictions will put somebody within the mandatory detention statute so that if they're detained during the process of their removal proceedings, they have no opportunity to ask to be released on bond. If you're deported because of a certain criminal conviction, you could be permanently banished from ever legally re-entering the country. And if you were to illegally re-enter, the penalties, the criminal penalties, are extremely severe. So criminal convictions in the immigration context are a big deal, right? I mean, there's a lot at stake. Removing individuals has also become a top enforcement priority. So moving from the legislative piece to the executive enforcement piece, the Obama administration's recent Felons Not Families prosecutorial discretion program has prioritized the removal of non-citizens with criminal convictions. So most recently, 59% of the 235,000 removals from fiscal year 2015 were due to individuals with criminal convictions, so they're deported because of a criminal conviction. 91% of all interior removals were based on criminal convictions. And somewhere between, I've seen numbers sort of fluctuating here, but somewhere between 50 to 70% of individuals who are in detention are in mandatory detention because of a criminal conviction. So that same mandatory detention that I just spoke about a few minutes ago. The term conviction in immigration law has a long history, longer than a century. So, for example, a law passed in 1875 excluded persons who are undergoing a sentence for conviction in their own country of felonious crimes. In 1917, it was expanded, so that had to do with exclusion. In 1917, the laws were expanded to the deportation end of folks who had entered and then subsequently committed a crime involving moral turpitude and could be deported for that purpose. Now, in the Immigration and Nationality Act, which was first passed in 1952, and there's been a bunch of amendments to that, the term conviction appears many times in both the grounds of inadmissibility, so the grounds that would prevent an individual from entering the country, and the grounds of deportability. Once you entered the country, the grounds of deportability apply to you if you've made a lawful admission. So determining when a conviction qualifies as a grounds of removal or triggers mandatory detention or triggers a bar to discretionary form of relief like seeking asylum can be very difficult to determine, right? Because you've got several different worlds sort of acting all at once. You've got two different sovereigns. You've got the federal government and you've got the state government, assuming that the conviction is a state conviction. You've got state criminal law and procedure working in tandem with federal civil immigration law. So figuring out when these two intersect, when they match up, such that a state criminal conviction can qualify as a ground of removal or some other type of immigration consequence, is a test that's fairly complicated to apply. But one of the first parts of that test that needs to happen is you need to determine whether the state criminal disposition would be considered a conviction for immigration purposes. And that is not always intuitive. It's sort of really the heart of my research in my paper here discussion today. So the reason that it's not intuitive is that the current definition of conviction for immigration purposes in the Immigration and Nationality Act encompasses certain kinds of state criminal dispositions that a state does not consider to be a conviction for state purposes. And again, this has to do with the deferral programs that I mentioned earlier. So let's say you've got a state conviction or a state disposition in which there was a final adjudication of guilt. The person pled guilty, the judge imposed a sentence, or the person pled not guilty, there was a trial, and there was a final verdict of guilt. That guilt was accepted and the final judgment was entered on the record and punishment imposed. Those are sort of straightforward. Those have always qualified as a conviction for immigration purposes. Where things start to get a little bit fuzzy, a little bit confusing, a little bit non-intuitive is when you've got dispositions where a finding of guilt is deferred, or a finding of guilt is withheld. So there's no final adjudication of guilt. There may be a term of probation or some sort of rehabilitation program that's imposed, but the underlying criminal sentence is not imposed. In some cases, there may be a final finding of guilt, which is then vacated or set aside if an individual successfully completes a probationary period. When those kinds of programs qualify as an immigration conviction, with all of the immigration consequences attaching to it, can be difficult to figure out. And when states have created these programs such that they do not qualify as a conviction for state purposes, but they do fall under the immigration definition of conviction, you've got a federalism problem where state authority and federal authority are sort of butting heads on this particular issue here. Okay, so with that as sort of background, I want to first talk about immigration law's definition of conviction. Then I'll talk about deferral programs, and then I'll sort of wrap it up with my discussion about the recent Supreme Court precedent. So as I said, federal immigration law defines conviction for immigration purposes, not state law. So this could be very confusing. This is really one of the main impetus for actually getting into this research and why I started with this topic, and that is part of my work. As Ryan was talking about earlier, I do Padilla advisals, so I advise our criminal defense clinic when they have non-citizen clients on whether certain charges are going to result in immigration consequences. One of the first things I do is try to figure out what kind of disposition is on the table. And often, at least at first, a lot of times what I'd find is the attorney where the student would say, oh, it's not a big deal, it's not going to result in immigration consequences, it's not a conviction. And you have to dig a little bit deeper than that. So in Massachusetts, we have something called a quaff, or a continuance without a finding. For Massachusetts purposes, that's a deferred adjudication, so final judgment of guilt is not part of that disposition, it's deferred. For Massachusetts purposes, that is not a conviction. But for immigration purposes, it is. And it's shocking to a lot of attorneys that that's the case, and a lot of clients as well. And it's not surprising why that's shocking. So prior to the statutory definition of conviction for immigration purposes, the term was defined by common law. And there are basically, of the cases that I've looked at prior to 1996 when the statutory definition was enacted, there are basically three themes in some of these Board of Immigration Appeals cases that I was able to garner. The first and really the foremost was this issue of finality. And so when the Board of Immigration Appeals was trying to figure out whether a conviction qualified for immigration purposes as a predicate offense for immigration consequence, one central aspect of that calculus was whether the disposition was considered final for state law purposes. When I say final, I mean that there was a final adjudication of guilt. Also, a second theme was that the conviction, or I shouldn't keep saying the word conviction, that's confusing, right? The disposition was considered a conviction for at least some purpose within the forum state. That was sort of the second theme in a lot of the BIA cases pre-1996, determining when a conviction qualified for immigration purposes. And the final was really the grappling with these two themes, the finality and when a conviction was a conviction, or disposition was a conviction for state law purposes, grappling with those two in conjunction with the uniform applicability of immigration law. And so these three themes netted out in decades of BIA jurisprudence on determining when a conviction qualified for immigration purposes. And so let me sort of walk through some of the more seminal cases on this to give you a better idea. So in 1942, the BIA decided matter of F. Matter of F looked at a California statute which allowed a defendant to withdraw his guilty plea upon successfully completing a court-ordered term of probation. The BIA said it was not logical, so it actually said not logical, to use this kind of deferral program as a predicate offense for an immigration consequence because it wasn't final. The adjudication of guilt could be withdrawn, could be set aside. Fast forward about 13 years to 1955, the Supreme Court weighs in on the issue in Pino v. Landon, looking at a Massachusetts disposition called an on-file or a guilty file. And essentially, the Supreme Court says the same thing as matter of F in a very short, basically a two-sentence opinion saying that a Massachusetts on-file disposition, which I won't get into, but basically doesn't result in a final adjudication of guilt, was not final enough to qualify as a conviction for immigration purposes. V. Landon was construed by the BIA to really, it was very narrowly construed to only apply to these on-file types of dispositions. But basically, to this point, the BIA was mostly concerned with giving some meaning to this conviction term that was commensurate with how a state itself would consider a conviction or a disposition. So there was some deferral to how the states viewed their own dispositions. There was some understanding that when a state was adjudicating a criminal issue, they were acting within their power, and they were owed some respect and some deference on that particular issue. In 1988, matter of Oscock was decided, and it changed the analysis. So matter of Oscock had a three-part test to determine when something like a deferral program qualified as a conviction for immigration purposes. So the three-part test included a finding of guilt, a court-ordered punishment, and no further proceedings necessary to determine guilt or innocence. So again, there was still some finality needed. But what matter of Oscock did is it took out the part of the test that required the forum state to consider the disposition a conviction for some state law purposes. So it sort of changed the game a little bit. And I think it's important to look at sort of what the political context was at this time as well. So this is 1988. We're sort of at the height of the drug wars. Aggravated felony definition comes into play. First enacted, there was three aggravated felonies: murder, illicit trafficking in controlled substance, and illicit trafficking in firearms. These cases, matter of Oscock, and some of the previous cases right beforehand were all drug-related cases. And so the BIA, I think, is particularly concerned with deferral programs around state dispositions that dealt with controlled substances. I think matter of Oscock is sort of a reaction to that and wanting to make sure that those kinds of programs didn't escape, the individuals in those programs didn't escape immigration consequences. So that political context is important to keep in mind. In 1996, the Illegal Immigration and Immigrant Responsibility Act, or IRA, was passed. And IRA defined convictions for immigration purposes. It amended the INA through this appropriations rider. There wasn't a whole lot of deliberation around the 1996 bills. And what the definition did is it took the first two parts of the matter of Oscok test and got rid of the third part. And so now the current definition that we're working with via IRA is a two-part test set in the disjunctive. So either test will, if the disposition falls under either of the two tests, you've got a conviction for immigration purposes. So the first test is sort of straightforward. Is there final adjudication of guilt? So again, individual pleads guilty, there's some kind of sentence entered into the record, there's a final adjudication of guilt, that will qualify as a conviction for immigration purposes. The second test states that if an individual pleads guilty, nolo contendere, or admission to sufficient facts to warrant a finding of guilt, and there is some kind of court-ordered punishment, penalty, or restraint on liberty, that state disposition will qualify as a conviction for immigration purposes. Now, that court-ordered punishment, penalty, or restraint on liberty has been interpreted very, very widely. It could be virtually anything. So probation counts, mandatory drug testing programs count. It's been interpreted very, very expansively. And again, so 1996, again, it's important to take just a quick look at the political landscape at this time as well. There was this heightened anti-immigrant sentiment in the United States at this time. You've got issues like Prop 187 in California. You've got the Oklahoma City bombing, the World Trade Center bombing. And you've got a House of Representatives under the control of Newt Gingrich, in which a lot of legislation was done behind closed doors. And you've got the 1998 elections coming up. Very popular campaign slogan at that time was being tough on crime and being particularly tough on non-citizens who have committed crimes. So it makes sense that the definition of conviction becomes so expansive. As I said, there wasn't a whole lot of deliberation around the 1996 bills, so there's not a lot of legislative history, but there is one particular passage that I think is important to note, and I'll come back to it sort of at the end of the talk here. And I think it leaves Congress's motivation quite clear. There's no secret here, and I'll just read you the passage. So this is in relation to the IRA's definition of conviction. So it says, aliens who have clearly been guilty of criminal behavior and whom Congress intended to be considered convicted have escaped the immigration consequences normally attendant upon a conviction. Even in cases where adjudication is deferred, the original finding or confession of guilt is sufficient to establish a conviction for immigration purposes. So, I mean, we could get into a whole discussion about whether, how accurate this statement is. I'm not sure it's fair to say that somebody who has a disposition pursuant to a deferral program is clearly guilty of something. There's many reasons why folks end up pleading to criminal offenses. But I'll set that aside for now, and just sort of keep that in mind. So this was Congress's, this was their thought process in terms of passing IRA's conviction definition. Okay, so as I was saying, at this point there is heightened criminalization, there's anti-immigrant sentiment, and there's some response to this on the state level. And some ameliorative programs that have sort of thwarted Congress's efforts to increase removals of non-citizens with criminal convictions. And those are the state deferral programs. So let me move into the state deferral programs now and talk about those a little bit. So every state now has some kind of deferral program. In 1959, there were only a few states that had such programs. But in the 90s and the 2000s, that exploded, and every state has some kind of deferral program. There's lots of different kinds of deferral programs, many, many different structures. But I'm going to put them into sort of two main buckets, which may not be fair because there's, as I said, there's a lot of different parameters at play here. So there are what I call pre-finding programs or pre-guilty finding programs, which I'll explain in a second, and also post-finding programs or post-guilty finding programs. So pre-finding deferral programs allows a defendant to serve, usually it's a term of probation, without having to formally enter a guilty plea onto the record. So it sort of happens prior to any kind of guilty finding. And for that purpose, it does not satisfy the INA's definition of conviction because there's no guilty finding. You don't get that. It doesn't satisfy that first part of the two-prong test. There's a whole bunch of different kinds of pre-finding programs. So Massachusetts has a pretrial probation program. There are even some programs that don't involve the court at all. So the federal government, the U.S. Attorney's Office has a program where essentially you enter into a contract with the defendant. And so it's between the AUSA or the USA attorney, the U.S. Attorney's Office, and the defendant to complete some program or probation or whatnot as sort of a prosecutorial discretion measure. The post-finding program is more interesting because a lot of post-finding programs, virtually all of them, will satisfy the INA's definition of conviction. But in most states, there's only a couple, I think. In most states, they are not considered a conviction for state law purposes. And so I want to give you an example of a post-finding program. So I pulled since we're in Ohio here, I pulled the Ohio deferral program, which some folks in here might be familiar with, something called intervention in lieu of conviction. Does that sound familiar? Okay. So intervention in lieu of conviction, I know there's some Ohio practicing attorneys in here, so I am not one of those attorneys, so if I get this wrong, please correct me. But my understanding is the structure of that program first requires a defendant to enter a guilty plea. And then there's a probationary term without a final adjudication of guilt. And if that term is successfully completed, then that guilty plea is set aside and the charges are dismissed. Does that sound fairly accurate? Sound right? Okay, great. Eligibility for that program, so I believe it's no prior felonies, and usually it's around alcohol or drug-related offenses, right? That program qualifies as a conviction for immigration purposes. It was a program that was created by the state to avoid collateral consequences, but immigration subsumes that program into the INA's definition of conviction. So that's just one example of a post-finding deferral program. And like the Ohio intervention in lieu of conviction, most post-finding programs are typically only for first-time offenders, low-level offenders. They involve what states consider to be non-dangerous offenses. Some states, these kinds of programs are only available to folks with low-level drug offenses, and in other states, any sort of drug offense, you're ineligible for this program. So the reason, as I've been saying, the states have these programs is to avoid having a state conviction and the consequences attached to that. So let me explain what I mean by that. So a state conviction can have a lot of different collateral consequences, right, that can be quite severe. Just to name a few, there's loss of employment, or inability or a bar to getting a future job. You could lose child custody. You could have your professional license revoked or inability to apply to a professional license, which obviously could affect your livelihood. So these kinds of collateral consequences have real costs for defendants. They also have very real costs for the state itself. If you've got a defendant who has a criminal conviction and is unable to reintegrate or integrate into society because of the stigma of this criminal conviction, that has a real cost on the state. That person can't get employment. That person's children are now in the foster care system. Those are very real consequences, and in many states, those consequences were the impetus for creating these kinds of programs. In addition, there are some very real costs in incarceration. If you don't have these kinds of deferral programs, instead folks are forced to plead guilty and end up in prison, that's an extremely high cost to the state, in addition to all the collateral consequences that the defendant experiences as well. So these programs really emphasize rehabilitation and reintegration. So reintegration, allowing somebody to be into society without having the stigma of criminal conviction. Rehabilitation piece, a lot of the probationary terms, usually there's some kind of treatment program that's required as part of the term of probation. So let me give you an example. Turning back to the Ohio deferral program that I talked about earlier, the intervention in lieu of conviction, I want to read to you a couple of Ohio appellate cases talking about, just a couple of blurbs from these cases, talking about the purpose for the intervention in lieu of conviction. So in 2000, the Ohio appellate court stated, in enacting intervention in lieu of conviction, the legislature made it a determination that when chemical abuse is the cause, or at least a precipitating factor in the commission of a crime, it may be more beneficial to the individual and the community as a whole to treat the cause rather than punish the crime. In another case in 2005, the court stated, for that reason, intervention in lieu of conviction is not designed as punishment, but rather as an opportunity for first-time offenders to receive help for their dependents without the ramifications of a felony conviction. And these sorts of examples, there are many, many examples of state courts talking about why certain states have decided to pursue these kinds of deferral programs. Okay, so now I want to move into my blueprint, I guess you might call it, for potentially lodging a challenge or a constitutional challenge to the Immigration and Nationality Act's definition of conviction. So as I've been alluding to, the definition implicates principles of federalism, which is the divide between the sovereign state powers and federal powers. And when these deferral programs are encompassed within federal immigration's definition of conviction, that INA definition purposefully frustrates a state's ability to structure its criminal dispositions so that collateral consequences don't occur. Those collateral consequences include immigration consequences, right? So you've got somebody who ends up getting deported, or unable to pursue a form of immigration relief, or detained mandatorily without having the opportunity to be released on bond. All of those consequences are just as relevant and implicate the same kinds of costs to the state and the individual as the state collateral consequences. So I think there's a real problem there. No longer is the immigration definition of conviction deferring to how states would consider a disposition to be classified. Now, immigration law is completely disinterested in how the states classify it. Because of the IRA definition, the issue of finality is also off the table. And so it creates this real problem, this real federalism problem. I'm not going to get into all of the Supreme Court cases that I talk about more in my paper, but I want to focus mainly on one, and I'll talk about a couple others afterwards. The main case I want to focus on is the United States v. Windsor case from 2013. That might come as a surprise to some that it's not an immigration case, obviously. That case has to do with gay marriage. So as a recap for Windsor, the court held, so Justice Kennedy, writing for the majority, it was a 5-4 decision, held that Section 3 of the Defense of Marriage Act which defined marriage to exclude same-sex marriage couples, was unconstitutional because it violated, quote, basic due process and equal protection principles. Section 3 of DOMA amended the Definitions Act, changed the definition of marriage, which was applicable to over 1,000 different statutes, federal statutes, and all of the federal regulations. Justice Kennedy's opinion, his majority opinion in Windsor, is really rich with federalism. There's a lot of federalism overtones in that opinion. He talks a lot about how regulating domestic relations is traditionally and exclusively a power that's left to the individual states, not the United States of America. He talks, and in doing so, he highlights some states who were in the minority at the time that had passed same-sex marriage legislation in approval of allowing folks, same-sex couples, to have the same rights as other couples who are married within that state. The court in particular was looking at the New York law, so the plaintiff in that court was from New York, but 11 other states had also adopted same-sex marriage legislation. The domestic relations powers that states had, Justice Kennedy pointed out, predated the Constitution. So these were powers that were not delegated to the federal government via the Constitution. So if you remember, any power the federal government has to be delegated to it via the Constitution. Powers that are reserved to the states are sort of collectively referred to as the police powers. So these domestic relations, the authority to regulate domestic relations was part of the police powers. Kennedy's decision in Windsor, as I said, it was decided on substantive due process and equal protection grounds, but there's a lot of federalism discussion in there, which is kind of curious, and scholars have sort of tried to figure out why that's there. But there are really two main concerns, I think, just from reading the opinion, that Justice Kennedy had about DOMA. First was the breadth of DOMA. So as I mentioned, it covered over 1,000 different federal statutes, changed the marriage definition in those statutes, and every single federal regulation. What Justice Kennedy was saying was that because regulating domestic relations is exclusively a state power, if the federal government wants to affect the rights and privileges of marriage, it is free to do so, but it must do so in a discrete manner. The statute has to discreetly address a right or privilege of marriage. DOMA obviously does not do that because it changes that definition for every federal statute, or I'm sorry, every federal regulation in most federal statutes. So that was Kennedy's first concern, the breadth of DOMA. His second concern was the animus in which Congress passed DOMA. He stated that Congress, by passing DOMA, purposefully discriminated against a class of individuals that New York and 11 other states had sought to protect. So not only do you have these two competing powers, state level and federal DOMA butting heads, but they're doing so in sort of opposite viewpoints. So DOMA is trying to discriminate specifically against individuals that New York has specifically sought to protect. When Kennedy decided Windsor on equal protection grounds and due process grounds, he didn't articulate a specific level of scrutiny. The court just sort of simply held that DOMA's marriage definition violated due process and equal protection pursuant to the Fifth Amendment. Did so after a long discussion about these federalism issues and the traditional rights that states have in terms of regulating domestic relations. So despite the rich overtones of federalism, Justice Kennedy found it, quote, unnecessary to decide whether this federal intrusion on state power is a violation of state power because it disrupts the federal balance. So if this discussion of federalism and this balance of state powers and federal powers was not necessary to the definition, to finding the definition unconstitutional, why is it even in there? This is what scholars have sort of struggled with. Justice Roberts, in his dissenting opinion, is concerned particularly about the federalism discussion in the majority opinion. And I think his concern is exactly what Justice Kennedy was trying to do. And that basically is that Justice Kennedy was, and this is something Professor Siegel at Duke University advances, so Justice Kennedy was purposely trying to enter the national conversation about marriage equality. The only way that he could really do that was through federalism. So using federalism, as Professor Siegel calls it, using federalism as a way station. So use federalism as a platform to highlight all of the different states that had enacted legislation in favor of same-sex marriage. And in so doing, he was signaling to the states that future constitutional challenges in states that purposely excluded same-sex couples from their marriage definitions might have a difficult time if their case reached the Supreme Court. And that's something that Justice Roberts, in his dissenting opinion, as I said, was very concerned about. So this signaling to the states, I think, is particularly important, and that's what I think is the real reason why there was this federalism discussion in Windsor. But let me move to some of the more immigration-related Supreme Court cases that I think will sort of bring Windsor into the immigration realm and sort of highlight why I think Windsor might be a template for lodging a constitutional challenge against the INA's conviction definition. So cases like Padilla v. Kentucky, Moncrief v. Holder, Mullooly v. Lynch, even U.S. v. Arizona, all engage in some level of federalism discussion to varying degrees. So for example, in Padilla, Justice Stevens recounts 100 years of immigration laws. And as he's doing that, he's talking about the increased consequences for criminal convictions and the simultaneous reduction of discretionary forms of relief when an individual has a criminal conviction. One of these discretionary forms of relief is actually a state remedy called a judicial recommendation against deportation. And Justice Stevens spends a bit of time in the decision talking about, for short, they're called JRADs. So he talks about JRADs and how in the state realm, JRADs could have a very real impact in terms of allowing somebody with a criminal conviction to escape immigration consequences. And in 1990, when JRADs were repealed, that was a real problem. So the Mullooly decision, or before I get to Mullooly, we talk about Moncrief. So the Moncrief decision reestablished the categorical approach, which I won't get into. That's a whole nother hour plus long talk. So it reaffirmed the categorical approach, which basically said when you've got a state criminal law violation, you have to only look at the statutory language and maybe, depending on the language of the statute, some of the record of conviction, in order to determine when that state criminal law violation qualifies as could qualify as an immigration, or it could be a predicate immigration to immigration consequence, like removal. So in so doing, that presupposes that you are placing some value, some deference on state criminal procedures to accurately let you know, when I say you, I mean the immigration adjudicator, let the immigration adjudicator know when there has been a violation. And so if you have deferral programs, which are considered convictions now, that for state purposes don't indicate a violation of a state statute because it doesn't result in a final adjudication of guilt, how does that come into play with Moncrief's categorical approach? I think that's really problematic. Finally, the Mullooly decision, which is a Kansas drug paraphernalia case in which an individual held, I think it was like 2 or 3 pills of Adderall in his sock, right? And so He was prosecuted under Kansas law and pled guilty to a drug paraphernalia offense. And there's something kind of interesting that I just want to highlight in this case, and that's actually in the oral argument. So in the oral argument in Mullooly, Justice Roberts makes this comment, which I'll read to you, and he's sort of dumbfounded at the lack of deference that immigration law gives to state criminal proceedings. Let me read to you his comment in oral argument. He says, "If it's not such a big deal that the state is willing to let him cop a plea to drug paraphernalia, why should that be the basis for deportation under federal law? The state thinks it's a very minor offense, and yet it can become so significant that the person's deported." I think that highlights this disconnect that we've come to at this point in immigration, where you've got a complete disconnect in some circumstances between state criminal law procedures and federal civil immigration law procedures. Okay, so how is this state level of deference applicable in the same-sex marriage context and the immigration context? If all of this, how does this also translate into challenging the INA's current definition of conviction? What would a federalism-based challenge look like, and would it be successful? Well, an obvious barrier to that challenge would be Congress's plenary power. Right? This is the huge barrier here. How many people have taken immigration law or are familiar with Congress's plenary power? One or two. Okay, so let me just sort of explain a little bit what Congress's plenary, but what that means. So basically, when it comes to the admission or removal of non-citizens in the United States, Congress, the power to do that is within the political branches of the government. In particular, Congress has the ability to set immigration policy such that it can impede on individual rights, so rights under equal protection. If it's doing so under its plenary power or its vast power, its absolute power in the immigration policy setting field. There are some limitations to this sort of nebulous plenary power, and there's some disagreement in terms of where this power comes from. But basically, it's incredibly vast power, and it's very, very hard to pierce. And it's something that I sort of referenced earlier. I think the immigration scholars have really struggled with trying to figure out how this power operates, where it comes from, where its weaknesses are. But the upshot is that equal protection claims are virtually impossible to advance to Congress's plenary power in the immigration realm. So the flip side to Congress's plenary power in the immigration realm is that all powers not delegated to the federal government via the Constitution, as I mentioned before, are reserved for the states. These are sort of collectively referred to as the police powers. So states within the police powers in particular, as we know now from Windsor, include the regulation of domestic relations, but they also include the legislative ability to enact criminal laws, to adjudicate criminal laws, to administer states' own criminal laws. So, how does the regulation of domestic relations and the regulation of criminal laws sort of interact? And I think that if you look at the definition of DOMA and you look at the definition of immigration, or the immigration definition of conviction, there's some real similarities there. There's some obvious differences, but there's some real similarities. So DOMA and INA, definition of conviction, they're both federal statutes, right? They both define a federal term. They both, I would say, arguably target individuals purposefully protected by the states. They both affect a state's ability to regulate and administer an area of law that has been traditionally reserved for that individual state. If you think back to the passage in Ira that I read to you about the passage of the immigration conviction definition and Justice Kennedy's discussion about the passage of DOMA, I think you could argue that they were both passed with a certain particular animus, right? The targeting individuals that states had purposefully tried to protect. And so I'll just conclude with the fact that I think that the similarities between Windsor, and especially if you bring in other immigration-related Supreme Court jurisprudence like Moncrief, Padilla, Mullooly, Arizona, I think that there's a real possibility that this court in particular would take a close look at the INA's definition of conviction. I am apprehensive, I'm very skeptical that they would actually find the definition to be unconstitutional because of the plenary power. But that doesn't mean that a meaningful review of the INA's definition of conviction it doesn't have worth in and of itself. And this, again, gets back to Windsor. So if the Supreme Court has the ability to give a meaningful review for the INA's definition of conviction, it can do so in a manner that highlights prior 1996 deference to states types of cases that deferred to states for the INA definition, or the definition of conviction for immigration purposes, and signal to states that it's the states, it's on the states, it's the responsibility of the states to develop types of dispositions that would purposely get around or thwart the INA's definition of conviction. So for that reason, I think that there is a meaningful review would have some success. I'll stop there. Thank you.
A few minutes left for questions. If you have any questions, we have Gabrielle and Alonzo will both have a mic, so go ahead and raise your hand, and they will get that to you.
I could repeat your question anyway.
Okay. So I'm actually really curious about this topic because I wrote my INLR paper about definition of conviction. However, I focused on whether the finality rule is still incorporated and whether a defendant had to either waive or exhaust all of the appeals right before that would serve as a final conviction. So I was curious if there's a circuit split between the 9th and the 3rd, what your opinions are on that, if you have them.
Yeah, so the question basically is about the current INA definition and whether this finality rule, this requirement is still in play, whether direct appeals need to be exhausted. So as you point out, there's a sort of a circuit split on this issue. I've found sort of on the practice, on the ground, in terms of practice level, it varies from court to court. So the immigration court in Boston, for example, if a criminal disposition has not gone through the direct appeals process, then they won't look at it. They won't consider it final. But I imagine it's different. You know, obviously, depending on what circuit you're in, it's different from circuit to circuit. I mean, it's a very interesting issue. I mean, my personal opinion would be that I'm sure you can tell from my talk today that we should defer to states, and it should be final for state purposes before we start attaching immigration consequences. Yeah. Right, right. So the question is, so where can Congress come in and say, we don't need to have a serious conviction or a final conviction, just any sort of indicia of criminality would be enough to removal. Is that fair characterization? Okay. So my understanding is that Congress can do that pursuant to the plenary power. They can do that right now. So they could say, rather than have a conviction definition, they could say, they could premise a removal on an arrest. I think that would be sufficient.
And then next, I agree with you as a matter of policy. It seems that if you've got these minor offenses, why are we deporting people for that? And I guess the underlying reason must be that people in Congress really want to increase the number of deportations, so they want to get people out of the country regardless.
Right.
They want to find reasons to do that, but that seems to be probably the reason they're doing this. But that kind of raises the question: where do you draw the line between your plenary power and what you're suggesting, which is the court takes a serious look at this conviction process? It does seem
Right. Yeah, no, I think it's a difficult sort of line to draw. Basically, Congress has plenary power. I mean, they could essentially do whatever they want in terms of some kind of reason for removing an individual. I mean, it could be as low as an arrest. I mean, the flip side to that, I think, is that this is why I think a constitutional challenge might not be successful in that realm. But the counter argument obviously is that an arrest or a minor offense or whatever really isn't an indication of criminality. But then you're getting into more sort of policy arguments rather than that could be founded in a legal argument.
Well, I'm a crimmigration practitioner, and I would agree with you that through the plenary power, it would be very difficult to move forward on a federalism means of trying to get things such as pretrial diversion not seen as convictions. However, I practice in both Ohio and Kentucky, and I see some very large differences in the state regulations. Kentucky, for instance, would not require a admission of guilt if the crime charged is a misdemeanor, and yet would require it if it is a felony that the individual is trying to get a pretrial diversion for. So, in the one hand, I can see, and it's quite clear that if you are charged with a misdemeanor, you get pretrial diversion. It's not a conviction for immigration purposes, whereas if it's a felony, it would be. Ohio, on the other hand, is completely insane. Ohio has allowed the pretrial diversion program to be administered by each prosecuting office. Ohio has 88 counties, so there's a minimum of 88 different perspectives. For the vast majority, there's nothing in writing, or if it is in writing and you request a copy, it can change capriciously and arbitrarily from one day to the next. No rhyme or reason given. It's just the prosecutor's policy. The prosecutor, at least in the state of Ohio, every prosecutor is elected, so they're all political animals, and therefore they have a tendency to go whichever way the wind blows.
Right.
So the problems that I would encounter in the state of Ohio is that I have a minimum of 88 different pretrial diversion programs, none of which is written in stone, none of which is really subject to judicial review because it's a prosecutor's voluntary program. And I have encountered in many instances prosecutors voluntarily changing the program to make it just about impossible for a non-citizen to enter the program, or certainly enter the program without an affirmation of the fact that they are guilty to whatever charge it is, be it misdemeanor or felony. Do you see, is there any way that one could challenge something like that on a local, statewide level and try to get a voluntary program seen as capricious and trying to get some sort of a single means of regulation that would be amenable, or at least let us know where we stand on each and every case?
Yes, that sounds extremely difficult to do. If it's being offered as a discretionary measure, and there's 88 different individuals that have different discretionary measures that they're weighing, without some kind of centralized ability to point to a particular program and have the DAs beholden to that program rather than this sort of ad hoc process. So this is before the charges are even filed specifically in court?
This would be when the charges are filed, but prior to there being any trial. So it's a pretrial program that the prosecutor's office in each of the different counties would offer.
Okay. And if the court's not involved in terms of administering the program? It's at the prosecutor's level. The court has to sign off on it, but basically they would follow whatever the prosecutor's recommendation is. And recently I've encountered in this particular county, in Hamilton County, a written plea of guilty going on the record to enter into a pretrial diversion program.
So then you certainly have court records showing that, yes, I did admit my guilt to
Right.
charge X.
Right. Yeah, boy, I wish I had a good silver bullet solution for you with that. That sounds particularly challenging. Oh, yep. My apologies. I can take questions outside.